Good day. Today we'll be looking at contracts. Contract is a relatively large area of law. As such, today we'll be looking at employment contracts. Specifically, things an employee should look for in their contract, important clauses that should be in their contracts. In a different session, we'll look at what employers should ensure is in their contracts to protect themselves as well as being in conformity with the law. Now, an employment contract sets out the employer-employee relationship. It's basically an agreement that sets out the responsibilities, the roles, salaries, and basically the relationship between the employer and the employee. First and foremost, you should ensure that your contract is in writing. Way too often you hear about persons having oral contracts with their employers. When you're contracting with someone for employment, ensure that you have a written document and that both of you sign that document. Do not take an oral contract and then later on, we'll come together and make a written one. No. It has greater strength in law when you have a written document. Secondly, you should always ensure you read through your contract. If you do not understand something, seek clarity. Ask somebody else that's working in the same place. Seek legal advice. There's so many options to you. But never go signing a contract unless you fully understand all the terms of the contract, whether in public sector or private sector. A lot of times we're very excited, you might land your dream job, get moved to a new department, and you're really excited about signing it. Be very careful. That excitement and that signing may very well put you in a peculiar situation. Another thing you should ensure is that you have a copy of your contract. You should not leave after signing a contract without having a copy of it. Do not let any employer tell you that you're not entitled to a copy of your written contract. Ask for your copy. Keep it safe. And if necessary, review it subsequently to see if any of your rights are being breached or any clauses or terms under the agreement are being breached. Now, an important aspect of an employment contract is your job description, your roles and responsibilities. Ensure that your contract has what your job description really is. Likewise, check to see what your roles and responsibilities are in that contract. That way you'll know what an employer can ask you to do and what they cannot ask you to do. Far too often you'll see somebody being contracted to be a cashier. That's stated on their contracts. The roles and responsibilities of a cashier is also in the contract. But then that cashier has to pick up the child of the employer, clean out the employer's apartment, something of the sort. Those are breaches of your contract. If you have a written agreement and those are not parts or those aren't terms or clauses in your contract, it's a breach and they're actionable. Your contract should clearly state what your working hours are. In Guyana, the normal working hours are 40 hours per week, which comes down to about 8 hours per day, 5 days per week, with 1 hour lunch. You could contract to work more hours than that. Some persons work 12-hour shifts. However, that should be clearly stated in your contract. The reason for that comes down to being paid for overtime. I'll deal with overtime later. However, always ensure that your working hours are a part of your written contract. Your contract would state how many days per week you should be working. Normally, persons work 5 days per week. However, you could contract to work more than 5 days per week. You could contract to work all 7 days per week. Once that is in your contract, there is no issue with it. However, if your contract states that you are supposed to work 5 days per week, any days besides that, let's say you are contracted to work Monday to Friday, and you're being asked to work on Saturday and Sunday, you have to be paid at a different rate for those 2 days. Additionally, Sunday in itself attracts a completely different rate, even if it's a part of your 5-day per week contract. If you work on Sundays, whether or not it's a part of your contract, you have to be paid time and a half for every hour or part of an hour that you work on that day. That's very important because a lot of persons do not know that Sunday attracts a different rate. One of my favorite clauses in an employment contract is remuneration. This basically sets out your salary. No matter what might be left out of your contract, ensure that your contract clearly states what your salary is. It could also state whether you'll be paid as an hourly rate, daily rate, weekly rate, whatever it is. But you must have what your salary is, and you must have when you will be paid. Whether it'll be weekly on Friday, fortnightly, or the last Friday of every month. It should state when your salary should be paid, and whether it be paid in cash, wire transfer, or a check. Note, however, that you must be paid no less than $44,200 per month. That is a national minimum wage in Guyana. And any payment outside of that is a breach of the law. Now we'll look at overtime. If you are contracted to work 8 hours per day and you're asked to work an extra 2 hours, those 2 hours are overtime. And you'll be paid differently for that. For example, let's say you work for $1,000 per hour for 8 hours per day, and you're asked to work an extra 2 hours. Those extra 2 hours will attract $3,000 added to your salary. That's because for every hour it's now $1,500 an hour. Likewise, if you have to work on a holiday or on a Sunday, you're also being paid time and a half for that day. So if you're normally working for $8,000 for 8-hour shift on a day, on Sunday, that becomes $12,000 for that Sunday alone. So you should know what your days of work are, what your hours of work are, so you could calculate your own overtime. Now, earlier I mentioned that you should know what your days off are. Likewise, you should know how much leave you're entitled to. In Guyana, a person is entitled to at least 12 days of paid leave every year. However, in your contract could have more than 12 days for leave. It could also state that you'll be paid for not taking your leave and how much you'll be paid for not taking your leave. It may also state a leave allowance that you may be given if you are to take leave. So ensure that you look at the leave clause in your contract. Not all contracts will have a leave clause, but you could ask about it. Make an inquiry. Benefits. You should also ensure that whatever benefits you're being promised by your employer is within the written contract that you sign on to. Which brings me to my next point. Your employment contract, your written employment contract, should be the whole contract. Everything that is promised to you must be and should be in that contract. Do not take a written contract along with an oral agreement that certain things will be given to you or certain things will be added. Have it reduced into writing. Even if it has to be an addendum, and your employer sends you a little letter or gives you a note that he signs, adding whatever new clauses are in the contract, or new duties and responsibilities and added salary that you'll be having. That must be in writing. So if it can be in your main contract, it must be in writing, and always keep it with you the same way you keep your written contract. Probation period. Some contracts have that an employee will be on a probation period of 1 to 3 months. Check your contract clearly. We have seen a few contracts that would have other persons being paid at a rate of half the normal salary during their probation period. That is illegal. So you should clearly look at your probation clause in your contract. Likewise, check to see how long your probation period is, and what are your duties and responsibilities during that probation period. Oftentimes, it is the same duties and responsibilities you'll be doing as a full-time employee. So do not accept half pay for doing the full work. Disciplinary actions. Your contract should state what actions can be taken by your employer for any breaches of the contract, any misunderstandings, or something of the sort. It should state if a notice should be given, how many notices should be given, how investigations will be done. And you as an employer, you have the right to natural justice under the law. So you must also be able to hear what you're being investigated for or disciplined for and be able to respond to it. However, some contracts may have that a person is also on half salary during the period of their investigation. Check your contract properly. Seek advice if you're not sure about something, especially in that particular clause. If you're being told to work as normal during that period that you're being investigated, then there's no reason for you to be paid half salary. Mind you, that is still illegal. But ensure that you check your contract before signing it. You do not want to later on have to go through the courts, probably hire an attorney to fight your employer because there's something like that in your contract. Likewise, check for your termination clause. Under what circumstances you should be terminated or could be terminated. How much notice should be given before termination. You should also check to see, or ensure rather, that both parties can terminate the contract, meaning that you can also terminate the contract with notice, or under certain circumstances, without notice. Check to see how long notice must be given. Promotions. Every employee wants to move up the ladder at work. However, when you're promoted, you have a new job description with new responsibilities and new duties. As such, you will need a new contract. So when you're promoted, you will be excited, you'll be happy, but also ask about your new contract. Check the clauses just like this. Just like your first contract, check the clauses in your new contract. Ensure that everything you think should be there is there. Likewise, your salary should be adjusted. Check to see if the salary is adjusted in your new contract. Do not take an oral promotion alone. You might not get the contract the same day, but inquire about it. And as early as possible, ensure you're able to sign it and keep a copy. And keep that copy safe. If your contract has been breached by your employer, or you believe that you're being treated unfairly by your employer, you have the right to legal recourse. You can either contact an attorney at law or visit the Ministry of Labor on breakdown. At the Ministry of Labor, you'll be interviewed by a labor officer who will then make contact with your employer and trying to find the best solution to your problem. Likewise, an attorney at law will interview you and give you what your options are, tell you what your options are. And from there, you will make a decision of what you want to do next. But let me repeat. Ensure you have a written contract. Ensure that you get to keep a copy of your contract. If you don't understand something in your contract, seek clarifications, ask questions. Check for the clauses in your contract. Ensure that the clause that speaks to your salary, your day off, how many hours per day you must be working, how many days per week you should be working, or per month you should be working, how much leave you're allowed to have, what disciplinary actions can be taken against you, your termination clauses, and everything else. And if you don't see some of these in your contract, raise it with your employer. Sometimes it could even be an oversight. This has brought to the end of our discussion on this part of employment contracts. On the next occasion, we'll look at clauses that an employer should ensure is in the employment contract to protect the employer, as well as be in conformity with the laws of Guyana. Thank you.
Audio Jungle.